Good morning, everyone. So we're about ready to start with today's side event, the Capacity Building Workshop on Navigating Digital Trade Law Landscape. My name is Athita Kaminder, and I head the UNCITRAL Regional Center for Asia and the Pacific. You would already know Luca. Luca is from UNCITRAL headquarters, and he was actually the first head of UNCITRAL RCAP. So RCAP celebrates its 10th anniversary this year, and we specialize in providing capacity building on legal harmonization issues, especially those pertaining to UNCITRAL. So we're very happy to collaborate with our good friends at ESCAP for today's event. We have three illustrious panelists this morning. Ms. Lockney Sue will first start, so I will introduce the panelists right before they speak. Ms. Lockney Sue will first start. She is a full professor of law at the Yong Pung Hao School of Law at Singapore Management University. She was previously attached to Singapore's Ministry of Trade and Industry, assisting in free trade agreement negotiations. And she specializes in trade and investment law, including areas such as FTAs, digital economy issues and agreements, and dispute settlement and developments relating to ASEAN economic integration. Lockney will share insights on ongoing trends in digital trade law, such as RCEP, DIPA, and WTO Joint Statement Initiative on e-commerce. And she will explain the evolution in RTA provisions on e-commerce and what those provisions are about in terms of content and underlying policy. So Lockney, I know you're online with us, so good morning, welcome, and you have the floor for the next 15 minutes. Thank you.
Good morning. Thank you very much for the kind introduction and greetings from Singapore. Thank you to the organizers for inviting me to participate in this workshop. I hope in the next several minutes to share with you some information and observations which will be helpful to you in your work in relation to digital economy and trade-related agreements. So if I may just share screen to provide you with some of the slides that I've prepared. If I can just check, is that visible to everyone? Okay, so yes. Thank you. So my topic that I've been asked to speak about is evolution of treaty provisions on e-commerce. So I have a pleasant task of setting the scene for my fellow panelists. So I will be giving a broad overview of where the treaty provisions have been going in terms of developments in the region and beyond. So just some general points to set the context for us to think about this topic. First of all, the whole point of having cross-border collaboration in relation to digitalization is to promote efficiency and trust in the environment, because we know that businesses and consumers and users of online transaction platforms need to trust the environment and need to know that the rules work in order to be able to use digitalized documents and platforms with confidence. So that's one common denominator, I think, that is shared by many regulators and consumers and organizations that are looking at rules for harmonization alike. Secondly, there's an element of trying to save business costs through paperless trade, as we've seen in the usual trade transactions. There's a voluminous amount of paper that can be passed from one party to another. And when you have multiple parties, you have multiplication of the number of paper documents. So that raises a lot of issues about business costs, because you have to reproduce the paper over and over again. You have to send it to multiple parties, and it's very inefficient, and it provides trade friction, and it allows, it creates more cost for businesses. The third point that is general is we begin to think, therefore, that there's value in collaborating across borders on digitalization issues. Because when we think about e-commerce, when we think about digital transactions, it's not just about one country. As the pandemic has shown us, it's very clear that we need to import, export, and get, for example, hygiene and health goods across borders. So in collaborating on digitalization, in facilitating trade, there is great value in that to move goods along. A fourth point that I wanted to make in general is that in e-commerce, as we talk about platforms where goods are traded through electronic websites and so on, and electronic documents, there are issues about legal recognition and security. So legal recognition of whether a legal contract in electronic form is recognized by a jurisdiction, and whether there's security in terms of the information that is in your transaction. So for business certainty, these are all important aspects to ensure that commerce can move along again with confidence. And one of the points that I want to highlight in the next several slides will be what's the role of law and what's the role of international agreements. And also within the concept of law, I will mention what is called soft law in the form of model laws, which jurisdictions or countries are free to adopt or not. So before I go on to talk about the treaties and the evolution in earnest, the general picture that we look at when we talk about international trade and digitalization and paperless trade is made up of all these symbols that you see here, the stakeholders in the international cross-border trade process. You will have someone who places an order, maybe through a mobile phone in the middle of the picture, and then the whole process is set in motion because it might be a consumer, such as the group of persons you see in the left side of the picture. And then the goods may then be ordered and transported through air, through sea. There are legal regulations on the right side. You see governing what goods can move in terms of what is required at each customs checkpoint and so on. There's also movement of data. You see the brain there. I'm just using that as to symbolize the movement of information and data. And also sustainability issues. People are very concerned these days about whether the goods are from sustainable sources. So that kind of data is also important. And of course, finally, on the right side of the picture, you see payment information issues as well. So when we think about all the stakeholders that are stitched together in just a single transaction where one person or one entity makes an order of goods or of services for that matter, it already triggers many considerations. How authentic is the information? Will the data be protected? Where's the data stored? How will a trader know that the documents are authentic, that are being sent across and collected for payment and so on? So we begin to see, therefore, the point I made in the earlier slide about the value of collaboration, because it's all cross-border, there are multiple parties, so we need some commonality in terms of the standards and the rules that tell us what works and what doesn't in the digital economy. So moving specifically to the idea of trade facilitation, this is something that many countries have been able to get behind because they see the value of processing trade transactions more efficiently with less paper, eliminating or reducing paper documents in favor of electronic documents where possible. And I say where possible because there are, of course, some situations where because of law, by treaty, you're required to have paper documents, so that might remain. But to a large extent, many documents can actually today be in electronic form and acceptable. So as I also mentioned earlier, the pandemic has made the sense of urgency to switch to electronic versions of materials very urgent, as we've seen, because with restrictions of movement and lockdowns, you need to be able to exchange documents without face-to-face signatures and paper documents. So that's added to the urgency, and the urgency in turn has triggered, therefore, a need to have clearer collaborative rules to deal with what would be standards or laws that make these transactions trustworthy. So in terms of trade facilitation, there are already there's already a lot of work going on. So in terms of treaty work in the World Trade Organization, there's a trade facilitation agreement that's been signed by multiple members of the WTO. UNESCAP, and I know that Luca will be speaking more about this, so I just want to mention this. UNESCAP also has a framework agreement on cross-border paperless trade facilitation. And of course, within free trade agreements that are signed by countries bilaterally or in a region, they also contain trade facilitation provisions or commitments. So we now see a picture that many countries are interested in trade facilitation, and part of trade facilitation involves the use of electronic documentation where possible. For example, in your FTAs, you will find that there are single customs windows obligations and obligations to switch where possible to paperless documentation to accept trade administration documents which are electronic in form. So again, all this calls for trustworthiness and clear rules as to what is acceptable or not. In relation to the last part of this slide, I just wanted to highlight 3 points, which is the value of collaborating on clear rules and standards. As mentioned, we are talking about many cross-border transactions that involve the movement of data, movement of documents that are electronic in nature. So if there is no collaboration, each country is going to do its own thing and have its own rules. It's going to be very messy. It's going to add to business costs, because businesses have to figure out which rules to follow and what is reliable and not. So collaboration is very important. Secondly, the value of model laws. Luca and other speakers will today mention other model laws, but one of the exciting model laws that Singapore has signed on to is the UNCITRAL Model Law on Electronic Transferable Records, the MLETR, because this model law allows a country to adopt legislation following its provisions to recognize what I call electronic transferable records. As you'll see in one of my next slides, electronic transferable records could include, for example, electronic bills of lading. For those who are familiar with trade, bills of lading are important documents of title which can be transferred from one party to another. So if there's an electronic bill of lading, how does a country recognize this? Does it recognize it or not? There is a model law by UNCITRAL to set out the rules for this, which Singapore, as I mentioned, has recently adopted. Finally, the value of treaty commitments. Treaty commitments refer to what are the obligations countries sign on to in cross-border agreements called treaties. They are legally binding. And so if, for example, Singapore and another country sign a treaty saying that we will adopt a particular model law, for example, the MLETR that I just mentioned, then it becomes an obligation for us to take steps to implement that. In Singapore's case, we've already adopted it. It's not because of a treaty commitment, but another country could, in a treaty commitment, say that they wish to adopt the model law, or, as you will see in examples later, principles in such model laws. So there are different ways to incorporate these model law provisions. So moving along, just to again set the context, when we talk about trade documentation, these are typical, the bullet points you see on my slide are typical documents that will be exchanged or sent in a transaction. So you have the invoice, you have the bill of lading, certificate of origin, insurance, and goods declaration about hygiene requirements being satisfied, and so on. The one I've highlighted in red, the bill of lading, is an example of a transferable document in law, as I mentioned, because this bill of lading in law can transfer title to the goods to another person. So it's critical, it's very important. And because of that, if you have an electronic version of this kind of document, it has to be safeguarded in a very trustworthy manner. And therefore, as mentioned, there is now a model law for countries to consider, which allows for rules to make this sort of electronic document transfer more trustworthy and be able to be used with more confidence. And again, I think Luca and other speakers will be mentioning this. I just wanted to touch on one other point, the development of blockchain or distributed ledger platforms, which allows for transparent recording of transactions among parties through electronic means of their trade documents. So some platforms will allow traders and their bankers, their insurers to all upload their documents in digital form into these what we call immutable blockchain records. They are kept in the ledger, and therefore everybody has a common record which is authenticated. The relevance of this is that if you have a transaction involving electronic versions of all those bullet point documents that I mentioned in the above, then all of these can be safely placed in the blockchain environment as well. And the MLETR, the Model Law on Electronic Transferable Records, also caters to the possibility of this kind of platform being used for such documents. And again, some other speakers may be elaborating on them. So in terms of the role and the interaction of national laws, we're all familiar with national laws because we all have our own laws, whether from Singapore or another country. In addition to the national laws which may govern digital issues such as whether electronic signatures are recognized, whether electronic contracts are recognized, whether electronic communications are treated as authentic. All these may be already in our national laws. In addition, there may be international agreements, you see the dark blue box on the right, which provide further guidance or further ideas on how these laws could be shaped so that you have cross-border collaboration and further clarity. So for example, through free trade agreements, through newer arrangements, which I'll talk about later, called digital economy agreements, and something called plurilateral agreement, which is something that is relatively new. For example, in the World Trade Organization, there's a Joint Statement Initiative, JSI, which is looking into e-commerce rules. So these could be common rules that are formed through collaboration and may be adopted through by countries into their national laws. The lower box refers to model laws that also relate to e-commerce. They may provide guidance and ideas in the activities and negotiations in the dark blue box. They may also, if you see the blue arrow to the left, model laws may also be directly adopted by countries if they choose to into their national laws. So as I mentioned, Singapore is one example that has adopted directly a model law on electronic transferable records into our national law, not because through an FTA we are obliged to, but because we decided that we would want it in our legislation. So in terms of the evolution, just to move quickly on to the next point, free trade agreements are broad agreements. They, as we know, seek to eliminate and reduce barriers in trade in goods and services, promote trade facilitation, investment protection, and a number of objectives. So more recently, some FTAs have begun to include what we call e-commerce chapters. And examples are the CPTPP and RCEP. And again, I think the other speakers will be elaborating. But just to provide a sense of what these e-commerce chapters contain, it could be a wide range of digital issues, for example, authentication of electronic signatures, transfer of data, data localization commitments, disclosure of source codes, collaboration on digital issues, and so on. And again, some of these provisions will also refer to the need to conform to international standards and model laws, as we'll see in some examples later. I also wanted to mention that within the ASEAN region, there's a separate agreement, which is not an FTA, but is the ASEAN Agreement on E-commerce, which came into force about a year ago. So for those who are interested, this also contains interesting provisions that we're talking about. So I just want to move on quickly to the digital economy agreements, because these are partnership agreements which are not FTAs, and they're relatively new. And Singapore has been involved in at least 4 now of these agreements, the first being the one with Chile and New Zealand, and then Australia, Singapore, and UK, Singapore, and then with South Korea. The South Korean one has recently been signed, but I haven't been able to locate the actual text yet. I think it hasn't been published yet, but we do have the text and the actual agreements of the first 3. So I'll give you some examples of provisions which refer to international standards and model laws in the first 3. So the first example is from the Chile, New Zealand, Singapore DEA, and you will see from where I've put the red arrows on the right that there are 2 provisions which specifically mention in this DEA that the parties to this DEA would maintain a legal framework which follows or is consistent with the principles of the UNCITRAL model law. This is one model law on electronic commerce in paragraph 8, and also the UN Convention on Use of E-communications. So this is already an introduction to provision in such an agreement where parties agree to look into these international instruments for the principles that will guide them in terms of electronic transactions frameworks in their own laws. And the second arrow points to the specific model law I mentioned earlier, which is the newer one, the UNCITRAL model law on electronic transferable records. And it says each party shall endeavor to adopt, meaning they will take steps to try to incorporate principles or even the whole model law, should they choose to, in due course. One more example is from the Australia-Singapore DEA. Again, I've highlighted with 2 red arrows where it refers to UNCITRAL model laws. And again, we see that these are provisions that steer the parties who have signed, Australia and Singapore, towards looking at these international instruments from UNCITRAL for inspiration in their electronic transactions regulations at home. And the third example is from the third DEA Singapore has signed with the UK. And again, you will see the same theme, that principles of the UNCITRAL model on e-commerce and the UN convention will be the legal framework that will help to govern. And also in paragraph 3, it refers to the parties wanting to endeavor a framework that follows the electronic transferable records model law. So we conclude from these recent agreements that there is interest in collaboration, there is interest in collaborating with a view to looking to these international instruments for the principles to be used. Apart from FTAs and DEAs, as I mentioned, the World Trade Organization has also been doing work on e-commerce provisions. And just to give you a quick overview of this, in 2019, 76 WTO members began work on e-commerce negotiations to try to find some collaborative rules on e-commerce. This negotiation was begun and co-convened by Australia, Japan, and Singapore. And in this next slide, I've provided the link for people if they are interested in following up on the joint statement. And this is really to endeavor to cover a wide range of issues in e-commerce. The number says 76, but I understand that by now we have over 80 WTO members that are participating to help shape these rules. And they are expecting to come up with a draft consolidated text by the end of this year. So I won't go through this, but it's just to give you a sense that the objective is to really provide a framework for within the WTO membership to have some clearer rules on e-commerce regulations. And this is the latest excerpt that I could find from December 2021, which gives us a broad view of what is contained in the WTO negotiations. So the first paragraph excerpt, you'll see the words in bold. These are the areas that they've already had convergence or more or less agreement in terms of the text for these issues, and they include paperless trade and so on. And of course, in the second paragraph, there are lots of other issues that they're going to be working on in the days to come. So just to conclude, therefore, I hope I haven't overstepped my time. Apologies if I have. Clear rules on digital economy issues can facilitate trade. Various instruments and initiatives, as we've seen, such as model laws and UN conventions, have been developed already to promote this, and it will help trade facilitation in terms of the certainty and clarity of rules. And finally, apart from the FTA e-commerce chapters, there are many other arrangements such as DEAs, which are evolving, and also the work I just mentioned under the WTO JSI by those which are participating in that set of negotiations. So with that, I will say thank you very much for your kind attention. Khop kun ka.
Thank you very much, Lakni, for setting that comprehensive landscape of the international trade environment and digitalization and digital trade law. I think the detailed overview is very useful for our next discussions. I understand Lakni will be with us through the end of panel 1. So unless anyone has any pressing questions, then I will save the questions for all the panelists until the end of panel 1. So thank you. So we will now move on to Mr. Wanawit Akubut, who I understand is also joining us online. Wanawit is principal partner and founder of Privy Consulting, and he has also been the RCEP chair of the Working Group on Electronic Commerce since the establishment of the working group under the RCEP in 2015 through 2019. He has also been Deputy Executive Director of Thailand's Electronic Transactions Development Agency and also advisor to the Permanent Secretary of Thailand's Ministry of Digital Economy and Society. So Kun Wanawit will share insights on how the RCEP chapter on e-commerce was negotiated, its main provisions, and what is expected for its implementation. So Sawasdee ka Kun Wanawit, you now have the floor for the next 15 minutes. Thank you.
Thank you. So thank you, Lockney, also to setting the ideas and on how we're going to discuss further. I would like to share the experience I have. Unfortunately, I don't have the slides because I think it's much better to share with you, and then you can take something back on how the negotiation have been done. So I think in people might familiar already with the asset text. I think I have 3 topics that I will cover. First will be the paperless trading. It's the Article 14.9. In fact, the introductions of this, we believe that when we start off in 2015, it should be very easy because the trade facilitation agreement entry into force in February 2017, which means when we start off, it's already concluded. But in the asset negotiation that start in 2016 to 2019, so it took 15 rounds of negotiation and ending in 2018. Even if the text that have been introduced, initially we try to integrate the ESCAP text also as well. In that way, we can have more operative text, including in the article. But we managed to get only a very basics that each party shall endeavor to make trade document available in public in electronic form and accept that only 2 operative. And there are a lot of discussion, a lot of footnotes. That country, even though they are a member of the WTO and have to pressing very hard to include the paperless trading into the text of the e-commerce chapters. And we do believe that without the paperless trading, it's not gonna move forward for other articles that relate to this. That would be the article 12.6, electronic authentication and electronic signatures. So this topic have a long discussion, even longer than the paperless trading. The problem that we see is the neutrality and interoperability. It's the challenge for policymakers to understand the technical aspects. And normally in the trade negotiation table, they normally bring the technical people in and they try to explain. And the bottom line is the implication of having electronic signatures, that how to make it interoperabilities, what are the government carve-out that they can put it in. Some countries do concerns about the technical capabilities, capacity building, how they're going to do. And one of the topics that have been discussed a lot, I think the country that are non-Latin-based characters, because all the trade document, yes, it needs to be in the Latin base for sure, no matter bill of ladings, and most of the technology developed in such a way that it could be able to handling the multilingual, especially the standard that are non-Latin based. When we try to explain all these, and then when you going back to the local law, for a country that not using English as official language, there is a huge gap between what the basic domestic law said and the document that they need to proceed that are English in the manual world that are non-digital, not end-to-end, and the document is just coming after the internal process that are manually processes. These are the big challenge, and we still do see that this is still the challenge. Even the names of the people who sign in the official documents, there are a lot of discussion on these issues that how we interpret their function and their names and the digital certificates that involve. Technology is there, but each individual country have to working on this aspect and fix the problem of their own. It's not just commercial off the shelf. And that's how we need to explain to them that how to get along with the digitalization from end to end. No matter it's a commercial invoice, Thailand is adopt also the CAI, the cross-industry invoice from UNCITRAL that do believe that it will be part of the fundamental infrastructure to make it more interoperabilities and neutralities. Without the government building these capacities, the text in the electronic authentication and electronic signatures would be difficult for policymakers to understand. And that's how we facing during the 15th round of negotiations. Some country, and especially when you try to introduce a new technologies, no matter blockchains and the trade document, the PEPL standards that's still based on the PKI to start with, and it's nothing wrong with the electronic signatures in the form of PKI, and Thailand have been adopted in the single window since the beginning. Some countries do not, and then they also start to introduce it for the platform. The world moved towards the new technologies, and electronic authentication and electronic signatures is a challenge, especially for the country around the table that are non-Latin-based character in their digitalizations. And I think it's still the challenge that the capacity building in the technical and understanding of the natures of the applications, the texts that been used in the government, if they are like in Thai, it's all still based in Thai. So we need to explain that to the policymaker for them to understand that how we overcome that, and we need to build a local capacity building to be able to collaborate. Otherwise, in collaborations, people tend to forget that the limitation that we are facing, especially on electronic authentication and electronic signatures. The other article is on the online consumer protections and personal information protection. That also a very challenge, because in the same times of negotiation, you realize that the GDPR, General Data Protection Regulation, came into force. And these articles of online consumer protection and personal information become a new world order that using this mechanism create the extra territory scopes, which affect also the government, how we carve out, how we handling the privacy law domestically, because at the end of the day, we also have to follow the international rules, law, and regulation. This article of online consumer protection and personal information protection is also discussed in APEC economy quite a lot. And lately, especially on the topic of OTT, over the tops, especially when Lockney proposed that there is a mobile become a major devices. Mobile is also under the chapters of telecom, trading services. But some of the article, for example, like location of computing facilities, that also relate to the personal information protection. Some countries have limitations on the personal information that could not be cross-border. If you go in the approach the same as EU, that tend to have this kind of whitelist or Article 44, and then Article 45 until 49 is the article that telling which types of transaction or which scenario that EU allow, or the whitelist country approach, and all that are being challenged in the court. That's why they have these charm tools. You can see that the introduction of ASEAN model contractual clause, that also a very good approach on collaborations and try to help cross-border transfer of information, that at least the government could have some certain policy space and could achieve that they not restrict the location of computing facilities. I think all the other article is not that sensitive, but I do see that this article of electronic authentication, electronic signature, and online consumer protections and personal information protection, it will be the challenge also in the WTO e-commerce chapter negotiation, that we have to understand the limitations and how the policymaker will understand what are the policy space that they would have when they negotiate the text in this area. One additional things that I also like to mention is also the electronic authentication, which could be interpreted as the identification, electronic identities that seem to be a hot topics. And electronic authentication is part, that is a one function of electronic authentication, is telling who you are and relate that to the context. Nowadays, the discussion around the universal electronic identification become a common issue, especially in the e-commerce world. If you're familiar with the cookie banner that need you to accept the cookies, and it will gone within the end of this year. And the way to work around on that to control the OBA, online behavioral analysis, is to have a common digital identifications. So the area in e-commerce that move forward, it not only relate to the trade documentations or electronic paperless tradings or gateway, single gateway, but if the majority is catalyst, how we going to use a common digital identity, that are the area that I think that will be challenged when we discuss about electronic authentication and electronic signature in the futures. Okay, and that's all I could share, and I'm happy to answer any questions that you might have. Thank you.
Thank you very much, Kun Warnawit. So you two will be with us through the end. So I will save the questions until until Luca has finished his presentation, if I may.
Yes.
So Kun Warnawit has provided very useful insights into the background negotiations of RCEP, especially on the policy issues and those provisions that were challenging, which I think might be useful for others who are seeking to navigate the digital trade law landscape with regards to the policy discussions and the complications involved, both on the international and domestic levels. So we move now from the RCEP example now to UNCITRAL text, and I'm delighted to introduce my colleague, Luca Castellani, who most of you, I think, already know. He's a legal officer in the Secretariat of the United Nations Commission on International Trade Law on UNCITRAL. And as mentioned, he is also my predecessor, first head of UNCITRAL's only regional center, the Regional Center for Asia and the Pacific, which is based in Incheon, South Korea. Luca is also as secretary of UNCITRAL Working Group 4 on electronic commerce. He oversaw the preparation of the UNCITRAL model law on electronic transferable records and the UNCITRAL model law on the use and cross-border recognition of identity management and trust services. He's also active in the region and in the world outside of the Asia Pacific region on providing capacity building in the field of UNCITRAL texts on electronic commerce and paperless trade facilitation. So Luca, I pass the floor to you.
Thank you very much, Atita, for the kind introduction, and good morning, but also I have to say good afternoon, good evening, everyone. We have quite a few colleagues online, and I understand some of them are actually from the Americas. So we are actually finishing their work day while we are starting our day here. My presentation will focus, of course, on UNCITRAL texts. I am very grateful to the previous speakers. Lochner, of course, set very well the foundation of this discussion, and then Juanavita provided some very precious and I would say rare insight on the actual challenges in negotiating and putting together, on the one hand, e-commerce chapters of regional trade agreements or other similar international agreements, and on the other hand, domestic legislation. And I particularly appreciated what he said with respect to the difficulty of mapping domestic legislation that often is not in English with the commitments in the free trade agreements. And I have to say also from what we see, how we follow now this major process of the joint statement initiative. And I would like to say some 80+ countries are directly involved in the joint statement initiative, but as a matter of fact, also the other 100 countries will be affected by that one way or the other, because when we are setting rules for the major economic players, this in some way reverberates on the rest of the world. So it is important that every country would follow that discussion closely. Very quickly, many of you are familiar with UNCITRAL. Those who are not, it's a commission of the United Nations General Assembly, and it's also the main legal body in the United Nations for the harmonization and the modernization of business law. In particular, in the field of electronic transactions, electronic contracting, and electronic signatures, UNCITRAL did pioneer work starting in the 1990s. Many countries in Asia and the Pacific, more than half of the countries in Asia and the Pacific, have already adopted UNCITRAL texts. And if we look at this summary of the legislative texts that are already available, we have 5 of them. I have to be very happy to say that I sent these slides 2 days ago, so now it's already outdated because we have 17 states parties to the Convention on the Use of Electronic Communications, thanks to the accession of Tuvalu yesterday. So there's something wrong, but I'm very happy that it's wrong because it means that we made progress. And of course, we have the 2 most recent ones, the model law and electronic transfer records, and the one on the use and cross-border recognition of identity management and trust services, which has been finalized actually in July this year. And those 2 model laws are the ones that I could follow more directly as secretary of the working group. Altogether, these texts of UNCITRAL have been adopted in more than 100 states. So definitely this is the global legislative benchmark. This is important to bear in mind when we come to see the commitments. Lochner has already mentioned what is available out there. One of it has gone in detail. CPTPP and RCEP, they have comprehensive e-commerce chapters. Of course, there is some significant similarity, both in terms of substance and also because many states are parties to both CPTPP and RCEP. And then we have, of course, WTO Trade Facilitation Agreement. I would like to say particularly important, not so much in terms of the commitments, but in terms of the resources, because there is the Enhanced Integrated Framework that is doing an excellent job at providing resources to countries that want to set up electronic single windows, and to do so, we need to have, for instance, legislation on electronic transactions or modernize their legislation. Then there is of course, the ESCAP framework agreement on the facilitation of cross-border paperless trade in Asia and the Pacific, and the visa workshop is organized in the framework the meeting of its steering committee. It's very successful, already 11 state parties. But of course, this is a forum for discussion and for suggestions on how to advance cross-border paperless trade in its various dimensions. So it can be B2G, G2G, but also, and of course, from our perspective, B2B. Lockton mentioned this recent and very important development of the digital economy partnership agreements. These are promoted by Singapore, and I have to say I found it extremely interesting that the first one, which was a trilateral agreement between Singapore, Chile, and New Zealand. Now it's been expanded; it's becoming plurilateral because the new states are actually becoming a party to that agreement, as opposed to negotiating new bilateral agreements. And so it was mentioned, for instance, negotiations. I don't know if they were concluded with the Republic of Korea, with the United Kingdom, I think they were concluded, but also with Canada, with China. So very important. This digital economy agreement provides a very good level of detail in the implementation. So if someone wants to see how these work together, it's possible to look, for instance, at the e-commerce chapter of CPTPP for the general overview of all the issues. And then the digital economy agreement would provide guidance on selected topics, for instance, identity management, for instance, electronic transfer records, electronic invoicing, and how to implement. So it goes one step beyond. And then it was already mentioned, the joint statement initiative on e-commerce. Now, the main message of my presentation is how ancestral texts actually help implementing these treaties. And the assumption is, of course, that countries that negotiate these provisions or the whole treaty, they actually want to advance in their engagement in the digital economy, and therefore very interested in actually realizing the benefits that they expect from these agreements. So there was historical evolution because when we look back at the first e-commerce chapters, maybe 20 years ago or so, we had selected provisions, for instance, references to electronic authentication that eventually became electronic signatures. And then, as we said, RCEP and CPTPP, they have a more comprehensive issue. We also find in some older trade agreements references to customs or to trade facilitation, also where we had an evolution from customs to trade facilitation, from trade facilitation to digital trade in a more comprehensive approach. One issue that is, in my opinion, very important and that oftentimes, especially developing countries are very concerned is about the binding commitment. How binding is the provision? Are we facing consequences if we cannot implement it? So most of these provisions, because of that, most of these provisions are not binding. They are maybe formulated as best efforts. But in other cases, they are binding. But I have to say, and here I agree very much with what Manowitz said, in many cases, especially developing countries, because they have less capacity, in many cases, they have already complied with the condition, but they are not fully aware of that. So they say, oh, we don't want to say we will adopt the model on electronic commerce of UNCITRAL. They say, but you adopted it 25 years ago. So, I mean, it's like, you don't have to worry about it, actually. Well, but just in case, yeah, okay, just in case, but you know, it's already there. So, so indeed, I completely agree with what Manowitz said. There is a problem of capacity building. There is a problem of providing the resources. From a legal point of view, there are different ways to adopt this enabling legal environment for digital trade. Of course, treaties normally they are directly binding under international law, of course, to the extent that the provision is actually binding. Or also this can be done through harmonization of national laws. Sometimes there are global models like was of UNCITRAL. Sometimes there are regional models. So for instance, here for Asia and the Pacific, I make reference to the data privacy pathfinder and the cross-border privacy rules as an example of how harmonization could be achieved regionally. And when it comes actually specifically to the cross-border agreement on paperless trade, this is an approach which is endorsed in the Article 10 of that agreement, so there is complementarity. Specifically, there are three ways in which ancillary texts interact with the free trade agreement. There can be direct reference, incorporation of provisions on indirect reference. Lockney has already made reference to some of these. So, for instance, this is CPTPP, Chapter 14, Article 14.5, 14.6. The goals, and I think she already showed the actual text, reference to adopting ancillary text, Electronic Communications Convention, the model on electronic commerce, general goal of pursuing mutual legal recognition and technical interoperability based on two fundamental principles which are underpinning ancillary text, which is non-discrimination against the use of electronic means, or legal recognition if you prefer, and technology neutrality. Now, one problem is, of course, the carve-out. One of it mentioned that there's too many carve-outs when, of course, the provision is less effective. Because when there are too many exceptions, when there are so many exceptions, the rule is not as strong as it should be. Here, you will see this is very similar to what you saw for CPTPP, but this is RCEP actually, Article 12.10. This is actually a mandatory provision which says shall adopt or maintain a legal framework governing electronic transactions, but it says taking into account the model law on electronic commerce and the Electronic Communications Convention. So it doesn't say shall adopt and maintain a legal framework based on like CPTPP, but in reality the practical effect is the same. And of course, the best way to satisfy both provisions is to adopt either or this text. In reality, the model law is the predecessor of the convention. So by adopting the convention, one adopts also the model law. It's just the model law operates domestically and the convention operates internationally. Sometimes there are also regional models that are not in Asia and the Pacific, but for instance, there is one of the Commonwealth Secretariat, and likewise adopting that would also satisfy. Now here you see a big provision on electronic authentication and electronic signature. It's a lot of words. I appreciate that, and it can be a little bit intimidating. This is actually Article 12.6 of RCEP. But in reality, if you look at the paragraph 1, this is the principle of legal recognition of electronic signatures and non-discrimination against the use of electronic signatures. So all of these can be actually implemented by adopting any ancillary text that has a provision on electronic signatures. It has to do with the ability of the parties to choose the type of electronic signature they want to have, and so on and so forth. And it continues, actually. It continues. So what is important in the slides are available actually online. So I mean, if you want to see the whole, what's important here is to see that here you have two principles which are, as I said before, underpinning ancillary text. Again, legal recognition, or if you wish, non-discrimination of electronic signatures, and technology neutrality. And the domestic law must comply with it. There are carve-outs, but again, by adopting ancillary text, this article is complied with. Here we have the cross-border paperless trade agreement, general principles. And again, principle A, B, C, this is Article 5. These are really the principles that are underpinning ancillary texts. When the framework agreement was drafted, so this is an example of indirect reference, because one has to know that these three principles are in ancillary text. But there is no doubt about it. So once one is aware of it, then we know that this is complied with by adopting those ancillary texts. So final considerations. As I said before, not only ancillary texts have been adopted in more than 100 states, but very interestingly, a majority of them are developing and least developed countries. In some regions of the world, not necessarily in Asia and the Pacific, but in other regions of the world, there is interest for regulation, for instance, consumer protection, or for instance, data privacy. But especially in developing countries, over-regulation can have an impact on the development of digital trade. So one has to strike a balance. And ancestral texts are known for being enabling legal texts. So they remove legal obstacles to digital trade rather than setting conditions for carrying out digital trade. We have to say that our experience with also with the direct reference in CPTPP and RCEP has not created issues. There are some countries that have ratified, for instance, CPTPP and never adopted UNCITRAL text so far. Maybe they will in the future, but this is in the end, it is up to the other member states of CPTPP to create a case which they don't have an interest in creating. So in the end, the real sanction is that these countries do not benefit from cross-border digital trade. The issue, especially in the developing countries, is more at the implementation stage. So we have to make aware not only negotiators, but also to build the capacity in the various countries of what is already available and of the opportunities. And then, of course, sometimes we see that there is the free trade agreement when there is the ancestral text, and then maybe there is another law, for instance, a general contract law that is not aligned with these laws. So one has to align everything to make sure that everything is consistent. When we look for resources, of course, resources are always scarce. So, but for those countries that are already in the framework agreement on paperless trade in Asia and the Pacific, we do have here some capacity and some resources to support them. And for the other countries, of course, we hope that there will be similar facilities made available soon. And that concludes my presentation, and I give back the floor to our chair.
Thank you very much to Luca, and also to Lakni and Kun Wanawit. So we have, I think, 2 minutes for questions, which our ESCAP colleagues have kindly brought up for us. So I'm just going to read out the 3 questions, and then maybe the panelists could answer them briefly if relevant to your presentation. So the first question here is, how best can countries in Africa, in particular LDCs, which we were just discussing, improve capacity development on e-signatures and introduce them into international contracts? The second question is, what is the better approach between A, having an e-commerce chapter in the existing FTA, and B, creating a new separate agreement on digital economy? So maybe that one Lakni could answer. And then the last question we have from online participants is, the most challenging part in customs administration is to ensure trustworthiness in trading across borders. Their concerns are about the number of customs declarations and supporting documents that are forged, and whether blockchain technology helped to overcome this issue. So the last question might be a little less relevant to our discussion, but maybe Lakni, because the second question seemed to be directly relevant to your presentation, you could talk a little bit about that.
Yeah, excuse me, certainly, thanks. I think, excuse me, I wouldn't say that one is better than the other. It depends in my observation on the status of the relationship between the trade partners. So for example, if the trade partners do not have an ongoing FTA set of negotiations, that doesn't preclude them from embarking on, for example, a separate DEA. So to focus their minds on digital economy issues, electronic authentication, and all the rest of it that needs to be covered in such agreements. So that's one point. The second point is that, of course, as I mentioned, for free trade agreements, the negotiations would likely take much longer because free trade agreements by their nature cover a wide swath of trade issues, not just goods, but services, investments, and increasingly all sorts of different collaborative chapters as well, including maybe now e-commerce. So one of the factors to take into account is that if one is negotiating e-commerce within FTA, then of course it's got to be in the package, and it will take a longer time perhaps than a standalone agreement like a DEA. The third point is, I think it also depends on the objectives of the countries. If the countries want to focus on specific issues because it's urgent that they deal with the cross-border digital economy agreements as a priority, then perhaps the standalone agreement might be one way to go. So just 3 quick points in response to that question. I hope that helps.
Thank you very much, Lakni. So I'm told we've been given a little bit more time. So after this round of questions, we'll also take questions from the floor. So if you could please stay around for a couple more minutes, that would be great. I think we're also going to look at the first question next. Luca will take that one. It's about providing capacity building, especially for LDCs.
Yeah, thank you. And in particular, I think this makes reference to Africa. And I think that we have, first of all, it is absolutely necessary to start investing on capacity building. This has been done to some extent, but not necessarily in the legal field. But for instance, UNCTAD has done good work on the e-trade readiness program and e-trade for all. When it comes to legal issues, I think we have 2 low-hanging fruit. One is there is the new African Continental Free Trade Area Agreement, and there will be an e-commerce protocol which is being negotiated. It is possible there to put some enabling rules, and it is possible also to imagine some mechanisms for capacity building. And likewise, in the joint statement initiative, and this applies, of course, not only to Africa, but to all the countries. If developing and least developed countries can join that negotiation, it is possible for them to put forward their arguments, and in particular, to ask for effective capacity building mechanisms. I believe, but this is of course not for me to say, but there is a perception that the WTO trade facilitation agreement is successful because of the EIF facility and the resources that are there. So it is possible to look at that as an example, of course, to improve, because everything can be improved, and to have a global, we can say plurilateral if you wish, but a global e-commerce agreement that can really help in addressing the digital divide. Because the digital divide is a dramatic issue, and we have to act quickly on it. And it is not that developing countries, and least developed countries, are structurally not capable of engaging in digital trade, is that they don't have the starting capital, in human capital especially, in order to start a process of innovation. So if we invest on that, then we can easily make progress. Thank you.
Thank you very much, Luca. I also see Kun Wanawit's camera has now popped back on. So perhaps the last online question you might be able to help us with. The question was about whether blockchain technology could help prevent or ameliorate the situation of forged documents in customs. So if you had any insights on that, that would be great.
Yeah, I think at least I also like to address the first question also, that we cannot avoid the issues on technical aspect of digital signatures and authentication is very complicated issue, and it requires a lot of technical capacity building. I like to raise one of the very important issue is that in the UNCITRAL model laws on electronic transaction, you have the definition on the sending, receivings, and most of the issue is related to one aspect of how we deliver the document that based on the email address. And the email is very standardization, even come from telex. No matter if digital certificate in X509 format, X400, so it's all technical and it's have the legal binding effects on the electronic evidence also. The issue is for the least development country in Africa, you have more than 100 language there. How you overcome that aspect? When will you could be able to have that email in your local language? I think there is a workaround on that, that we need to working with the international organization like ICANN, International Corporation, and assign name and number. We have the international domain names groups that working, and also the share in 4 countries working on this harmonization on standardization and doing the interoperability and universal acceptance to all the email platforms and the others. And this aspect is also related to the issues of the blockchain aspects as well. There are a lot of technology that are coming later on and did not touch on the basic understanding of the definition of sending, receiving, who is receiving this, and the identity that's still based on the email is still the key on credential in international. And I urge the country in Africa that list development, because you're the only one that could be fixed. We already catalyst 47 language. Now it's getting more and more, but I did not see in the table that is a country from Africa. That would be help, and it's also related to the blockchain. And I think the blockchain, you have a session discussed later on. I think that they might be able to address that much better than I do. Okay, thank you.
Thank you very much. I see a question from the floor.
Thank you. My question is more on the splitting of declarations under just to avail of the de minimis value. Let's say you bought 10 pieces and the total cost is $1,900 US. So instead of declaring the whole purchase, you split it so that you can avail of the de minimis value. So my question is this allowed for you? And this could be linked also to identity management. So in your risk profiling and targeting activities at the national level, you can aggregate all the transactions. And what is the lead time for you, let's say within a month, because it's quiet in the legal framework? Thank you. What is your view on this?
So, Luca, did you want to take a crack?
At a very general level, there is, of course, a trend towards increasing taxation of physical cross-border e-commerce. And these are issues that may or may not find some support in international agreements, but more often it's national legislation that is relevant for that. We have to separate 2 issues, that is to say, if legislation, for instance, like in Singapore, in Australia, sets a certain amount after which there is taxation on the transaction, then of course there is an issue of proper identification of the seller, because this is a matter of enforcement, identification of the seller, and then enforcement. So the idea behind is that, let's say, a seller that sells more than a certain amount in value of goods to a certain country will declare that and then will comply with that. But below that threshold will not have a need to declare and will not have a need to pay tax. Identity management can help, and this has to do with using some universal identifiers. Some of them are being actually promoted and suggested, but I've never seen that done to that level of detail in a international trade agreement. It is done mostly at the implementation of the operational level. Of course, this has a lot to do with identity management. It has also to do with electronic invoicing. Let's say people are working towards that. Before getting there, also one has to see if in reality what kind of problem this is creating in the context of the specific country. Because in certain countries there are substitute goods, in other countries there are no substitute goods, and even in certain countries, for instance, I remember recently discussion in Central Asia, but the problem was actually competition from contraband goods. So the issue was not online e-commerce and physical commerce, but it was legitimate online e-commerce and physical contraband. So there was an issue of not penalizing too much online e-commerce, because then otherwise people would buy offline and would buy in the black market. So it's a bit complex.
Yes, please.
Thank you, Madam Chair. I think we all agree that e-commerce trade is moving to e-commerce, and I just like to get input or from our panelists if there are discussions on regulating or enforcing regulation on the platforms. I understand that most of these e-commerce platforms are based outside the country. There is concern that these platforms are always pushing for customs or the countries to be more quicker in the release of their transaction, but they are the source of data, and of course we have concerns that in the contents they are giving online are not regulated. There are issues on IPR, there are issues on consumer protection, and for us, like for customs, there is concern that there is a need for them to provide advance information. I think they're demanding for customs to be more quick in the flow of goods, but there is still no clear regulation on how they themselves regulate the sellers, the content, and the informations that they possess. Thank you.
Thank you. Lakni, do you think you would like to address this question?
Yes, thank you. I was about to raise my hand, and indeed I did. I think that it's a combination of the provisions that you find in some of the FTAs, which do deal with platform liability and platform obligations. They're not in all FTAs, but we're beginning to see some provisions regarding websites and what the obligations are. And I would say that in relation to such websites, is the customs concern is what you have raised, but we do see some provisions on online consumer protection, which has implications for such web operators, and also the protection of data and so on, and the use of data and transfer of data provisions, which would also regulate what they do. But in terms of the customs regulations, I personally haven't seen direct reference to web platforms obligations vis-a-vis customs authorities, and perhaps the other panelists could speak more to this.
Thank you very much, Lakni. I actually think we're out of time. We're out of time. So thank you very much for your input. So I will now pass the floor to the moderator of our second panel. And I think, again, Lakni, Wanawit, and Luca for their very informative and enlightening presentations this morning. Thank you.
Thank you.
Good morning. If I can invite Brian, Mr. Sakan, and Sven at the head table. I sit here. Annie, if you can share my presentation. Thank you very much for the speakers and moderator from the part one, which has set some ground for discussing further of some of the practical experiences that we have experienced in Asia and the Pacific. Before moving on to the speakers, I would like to give you a brief introduction of the tools that we have been using for the cross-border paperless trade legal readiness assessment and such. So I need to start from the readiness assessment for cross-border paperless trade. For those who were involved in the standing committee discussions for the past 2 days would have seen and heard about it, but it's basically assessment of legal and technical readiness to identify where the country stands and to analyze the gaps. It then, based on the assessments, lead to recommendations and action plan for countries to move forward towards cross-border paperless trade. Once again, for those who are involved in the standing committee discussions, these action plans are basically the basis for your national action plan in order to implement the framework agreement articles. So these readiness assessment were developed by the legal and technical working group under the interim steering group, which preceded the standing committee and paperless trade council before the framework agreement entered into force. So legal readiness checklist has 4 components, which includes electronic transactions and signatures law, laws regarding paperless trade systems, including national single window, and cross-border aspects and other considerations such as liability issues, dispute settlements, and electronic payments and such. It does have the other component, which is a technical readiness, but I wouldn't touch upon it because it's not relevant for this session. But here we have the readiness assessment guide for cross-border paperless trade, which can be accessed online at digitalizedtrade.org. And this is an interactive website that anyone can access and utilize it for the self-assessment of the readiness assessment. But what we have done is we teamed up with a team of experts in order to conduct some studies. But I briefly show you one page of the readiness assessment guide. So there would be a question according to the checklist with all the explanatory notes and good practices for each question. So basically it does enable anyone to conduct self-assessment. But as I've said, we teamed up with international and national experts and completed 15 studies in Asia and the Pacific over the past 3-4 years. And we have 4 ongoing and planned studies. In addition to the guide, we have cross-border paperless toolkit, which is co-published by the WTO in collaboration with ESCAP and UNCITRAL in 2022. It does have an objective of raising awareness of technical and legal tools to adopt cross-border paperless trade systems and national single windows. And this publication specifically builds on the guide and the corresponding checklists that I have introduced just now. I would like to note that it is very encouraging, and we are very proud that we have developed the checklist as well as the guide from the participation of ESCAP member states through the interim steering group in collaboration with international development partners as well as experts, and it has reached to the global audiences and global use. So I think through the framework agreement, once again, it's an Asia Pacific regional initiative, but we do see the potential of collaborating and really advancing beyond Asia and the Pacific, as evidenced here with the guide and the toolkit. So for the sustainability, I really need to emphasize that in order not to reinvent the wheel, as well as really reaching to those who would be utilizing this guide and the toolkit, it is based on the solid partnerships. So starting from the guide, it is a core product by ESCAP and UNCITRAL, financially supported by EIF as well. The toolkit, as I've said, it's between WTO, ESCAP, and UNCITRAL. ASEAN has identified framework agreement in the work plan on the implementation of ASEAN agreement on e-commerce. Pacific Regional E-commerce Strategy and Roadmap also has identified framework agreement as well as the readiness assessment. ECLAC, which is our sister regional commission in Latin America, they have supported the multilingual guide and Mexico's study, and they are planning to expand it to other countries. So once again, I just given you a brief introduction of the tools. You are very encouraged to visit these websites if you have not done yet. But also, I would like to emphasize that it is based on the contribution of all the ESCAP member states and the parties to the framework agreement, as well as the experts and international development partners. So we are really grateful for the partnerships and the collaboration we have conducted. And with that, I wanted to introduce the speakers in part two. So we have a Mongolian representative and Tuvalu representative, as well as two experts. So I will introduce Mr. Derga Bayasaikan, State Customs Inspector of International Cooperation Division, Mongolia, for introducing and sharing experiences of Mongolia.
Good morning, everyone. Now I'd like to talk Mongolian country experience. In this case, when I was preparing this presentation, I had very vague understanding of the e-trade and D-trade. I couldn't distinguish these two notions, but I think my presentation will not depend on the clear differentiation of this. And so just I will talk about the laws which applied for Mongolia now. And as regards the international treaties to which Mongolia is a party, is the United Nations Convention which relate to the digital trade. Mongolia is the party to the United Nations Convention on contracts for international sale of goods since 1999, and Mongolia is also a party to the Kyoto Convention on simplification and harmonization of customs procedures, revised Kyoto Convention since 2006, and we have only one free trade agreement, which is concluded with Japan. It entered into force since 2016, and also the WTO free trade WTO trade facilitation agreement is in force for Mongolia since 2017, and the Convention on the Use of Electronic Communications in International Contracts. Mongolia acceded to it in 2 years ago, and UN this framework agreement on cross-border paperless trade in Asia and Pacific, and we joined this year to it this year. A Convention on cybercrime, we are not party to this convention at the moment, and also we are Mongolia is not a party to the Convention on the recognition and enforcement of foreign judgments in civil or commercial matters. These are the laws we apply in the area of e-trade or D-trade. This is of course, the main laws are the Civil Code and the law on consumer protection, the law on credit information, the criminal law, the law on national payment systems, the law on supporting youth development, customs law, the law on custom tariffs and custom duties, and the last two laws are now under revision. We want to renew it. The drafts are ready now. And the law on e-signatures, the law on banks and legal entities, money deposits, money transfers, and loan activities, the law on cybersecurity, the law on personal data protection, the law on public information transparency. And these are the laws Mongolia has now in force, and now we don't have law on digital archives, and also no law or no provisions on functional equivalence of electronic and paper-based transactions. As regards the national policy documents, in 2010, we had the national security concept of Mongolia, and 10 years later, we had now the vision, the parliament adopted the vision 2050, and also the action plan for implementation of this vision was adopted, and also 4 years government action plan was adopted in 2020. As e-governance initiatives, and there are a number of initiatives now in place in Mongolia. To name a few, the new digital systems such as Lawmaker and Law Forum for drafting and discussing bills and promoting laws are now on operation, and more than 500 e-services became available on the integrated digital government service system, which is named e-Mongolia, and more than 60 private and public organizations have access to it. The Ministry of Digital Development and Communications was established in 2022. The government aims to make at least 90% of all public service available on the platform in 2021 to 2024. In 2022, the Ministry of Digital Development and Communications was established. Oh, I repeat it, I'm sorry. The government agencies use XYP platform for electronic data exchange since 2016. And we have now the National E-Commerce Task Force established, and this task force is headed by the Director of Foreign Trade and Economic Cooperation Department of the Ministry of Foreign Affairs. And this task force includes most of government agencies, and focal point is also Ministry of Foreign Affairs, and secretarial work is done by Minister of Foreign Affairs. Thank you very much for your attention.
Thank you very much. If I can add just one more activity of Mongolia, they are also participating in the joint task force He would need to move on to that meeting. So if you have any questions specific for his presentation, please speak now. Okay, I see none. Thank you very much. And I will now move on to the next speaker who's online. Mr. Falema Pita, Acting Head of Department of Trade in Tuvalu.
Hello everyone. Can you hear me over there?
Yes, we can.
Okay, thank you, Chair. Good morning, good afternoon to everyone online and in person at the workshop over there. Thank you for the opportunity, especially for Tuvalu to give to share some of their experiences in terms of this, the framework, the cross-border paperless trade framework. Apologies from here, I don't have a presentation to share with you, but I'll just be brief in our experience and what we're working on in our progress so far, especially in this framework. I'll be talking about mainly the background and mainly our interest in this framework and why we are interested in working and putting this framework in work here in Tuvalu, and also give some brief updates on our involvement and our work in the cross-border paperless trade readiness assessment, as well as our interest in Tuvalu's ascension to this framework. So from here, just some few background notes from here for Tuvalu's interest in the framework agreement. In Tuvalu's National Strategy for Sustainable Development for 2021 to 2030, e-commerce is a priority, especially under the strategic priority area of the enabling environment, which deals with harnessing the digital transformation to improve lives. And also in that particular area, it aims to develop inclusive digital economy by fostering virtual activities, and also to develop a legal and regulatory and standards framework required to promote investment in and use of digital technology. Also, we had a rapid e-trade readiness assessment, which was conducted in Tuvalu. And one of the objectives in the action matrix, it was recommended that our Tuvalu's participation in the framework would accelerate readiness in cross-border paperless trade, as well as accelerate implementation of paperless trade measures in the country. And also acceding to the framework is also one of the targets, as mentioned earlier, in the Pacific Regional E-commerce Strategy, which recommends to accede to the framework agreement on the cross-border paperless trade. So through these different initiatives and objectives in on a national and regional level, this is mostly why Tuvalu was interested in involving ourselves in this framework agreement. In terms of the readiness assessment, Tuvalu has worked together with with the UN ESCAP Secretariat in conducting a readiness assessment for the country, mainly on assessing the technical needs, technical capacity, as well as the legal frameworks in the country. We've been working with the local consultants being Duidalan Susana, as well as some of the international consultants being Sue Kim, Alvin Ma, and John Gregory on performing this activity. Early this year, we've been able to hold consultations with stakeholders, which would reinforce the needs and also give more data, especially for this readiness assessment. And also through consultations with stakeholders, last month we've been able to hold a validation workshop especially to validate the data that was gathered for this readiness assessment. And after this was done, we expect a final draft for this readiness assessment to be finished by next year, early next year. In Tuvalu's ascension to the framework, throughout this year, we've been giving our interest, Tuvalu's interest to WASI to the framework. So we've gone through the procedures, the parliamentary and legal procedures, and it's been taken up to the cabinet for our country. And upon recent cabinet decisions, they have agreed to sign the agreement for this framework, and we have signed this framework, this agreement, by our head of state last month, and we have sent this, and we have sent an e-copy, and we have sent the hard copy by DHL to be deposited to the UN in New York. So we're still waiting news upon that, and once they have received, we'll get further confirmation on that. So for Tuvalu, we're acceding to the framework agreement. But more in all, that's most of the updates and our work so far in the cross-border paperless trade framework area. And once again, from here, from Tuvalu, I would like to thank ESCAP for all the work and assistance they've been able to give us in Tuvalu in this area and helping us in this matter. Thank you, and that's all from me.
Thank you very much, Mr. Peter. Just to complement what he has said, we just received the notification from the OLA yesterday, so it has been formalized and finalized. And also to add, Tuvalu actually had acceded to the UN Electronic Communications Convention, commonly known as ECC, and Mr. Luca Castellani, who's sitting here, and he mentioned in his earlier presentation. So UNCITRAL has been really very supportive of the entire procedures on ECC, Electronic Communications Convention, for Tuvalu's accession as well. So we would like to congratulate Tuvalu double times for acceding to 2 treaties. So thank you very much, Mr. Peter. And now I will move to Mr. Brian Tan, partner of Reed Smith.
Thank you. As my presentation comes up, I would first want to acknowledge some of the speakers in the first session, because there is Professor Su, who was my professor in law school days. And so it's always very unnerving for students to follow their professors after that. And I assure you that I agree with everything she says. And in fact, some of the topics that I am going to cover have already been covered by her and the other speakers. So what I'm going to do is just to share my perspective. So if you can move on to the next slide, please. Oh, great. Great. So we briefly talked about some of the tools available. I'm not going to go into details, but there are a lot of tools that have been created to date. A huge bunch of them come from UNCITRAL. So a great number of model laws. They're soft law, but they're very useful. So for countries that are looking at possible laws, you do not have to reinvent the wheel. It's safe to say also that because a lot of countries have implemented these model laws, any subsequent litigation, which then refines these laws, can then be shared with other countries. And UNCITRAL does a job of also evaluating court cases that follow these laws. And I'm, from my memory, very few cases have successfully challenged or pointed out errors in these laws. So you are benefiting from really a lot of experience that other people have contributed to. Some of the other work has also been done at the United Nations level as well as at OECD level. The cross-border paperless work is not just confined to the CPTA that we are doing here. Some of the documents that I've talked about, the MLES, the ECC, also have provisions that support the cross-border recognition of electronic signatures, which is a key portion. In addition, the countries here have already signed on to the CPTA, in which you commit to facilitate the establishment of mutual recognition of digital signature frameworks and to facilitate the cross-border electronic transactions and the use of electronic signatures. Okay. Sue briefly mentioned this, and I would support that. The number of tools that have been created are truly impressive. And I think what's more impressive from that figure that she just mentioned, in the last 3 years, 15 countries have completed their assessments, the legal assessments and the technical assessments. That's 15 countries over a period that was interrupted by a pandemic, which curtailed a lot of travel. And that's an impressive number, because if we had, without those tools, we'll probably be at maybe 1 or 2. But we could do 15. As those tools get better, we expect more countries to do it. Another side effect or another benefit of those tools is a country can do that legal assessment or the technical assessments as many times as they like. They can do one before preparing for a session, after a session, as a post-mortem after passing laws, to see where they stand. They could do that without telling anyone either, which might be useful for them. And that's a lot more flexibility than you had with a lot less cost and overhead. So I do encourage you to make yourself available to those tools again. There are, I think, further sources of help that you can think about. And so there are a lot of countries that have already done that. As you can see, it's a growing list. And so you can always learn from the experience of the other countries. We've just heard from Mongolia. Those are good experiences that they are sharing. And, you know, we all learn from each other as we go along. We do have external experts available. And again, that's a body that's building. For a sustainability measure, those tools and the expert ensure that this body of knowledge continues to be preserved and continues to grow. As I mentioned, we have also the UNCITRAL text, and the checklists and the guides that go along with the tools are also very helpful. So I will talk a little bit about some of the upcoming issues we see in digital trade. The first one, again mentioned by some of the speakers, is that of electronic payments. It's a super topical issue, seeing what has happened to the cryptocurrency world. But believe me, I don't think we've seen the end of that. Cryptocurrency will continue to evolve. You would see countries, I think, considering issuing their own central bank digital currencies. You would see them trying to handle cryptocurrencies. You would see them certainly trying to encourage digital payments. And when it comes to digital payments for a paperless trading system, you can see the advantage that that will pose, because if you're dealing with data that's already exchanged digitally, if you can then facilitate that payment digitally, so whether it's PayPal, it's Stripe, it's some form of a digital currency. When you digitize the entire chain of payment, including the electronic bills of lading, which I will just talk about after this, you bring everything up to a new level. But with every new technology, there's always new risk. There are new challenges. So that's one area to really keep an eye on. We talked a little bit about Melita. Melita is your model law on the electronic transferable records, which UNCITRAL has come up with. I think it's working party number 5. And to date, I think we have a handful of countries, 7 or 8, who have already passed. But I think more ominously or more encouragingly, the number of parties reportedly looking at passing it include the G7 countries. The United Kingdom has come up very strongly in maybe the last 4 weeks, talking about this quite extensively, I think even in Parliament, and also the European Union. That's on the country side. On the private party side, a number of electronic bills of lading programs have been taking place. So this was created about 2 months ago. So I've got ICC, HSBC. I've just taken out IBM, Maersk, but you still have other entities like Trafigura, Standard Chartered, JP Morgan, Shipping Lines, OOCL, Costco, the Chinese, PIL, I think the Hong Kong Singapore line, Alibaba, and DBS. And you're seeing that more and more commercial entities are moving into electronic bills of lading pilots. And my point about this is, while the laws give the framework and the laws are important, I think it's also very significant that commercial entities are beginning to think about electronic bills of lading. Obviously, there's a commercial element in it for them. They would not do anything that they feel has got utility to them. It helps them either save money or prevent them from losing money or helps them make money. Commercial entities would do that. But the fact that that many major commercial entities are going to it, I think that's something to really keep an eye on. It's all not rosy though. We talked a little bit about data localization, and the threat of data localization is continues to rear its head. And it's one of those things that has an ebb and flow. In some years, more and more of this is happening. In some years, less of this is happening. So 12 months ago, if you had asked me about this, I would have said that maybe the threat is receding. But in the last 12 months, countries seem to be turning back into looking at issues on data localization. So we've done a heat map here of where the countries that are looking at data localization are. And so kind of red and orange are not good from that point of view. And you can see that the countries that are looking at either some laws on data localization or significant laws on data localization are mainly in the Asia Pacific region, where ESCAP is. And so this is something to really think about seriously, because by imposing data localization laws, inevitably some part of cross-border paperless trade will be impacted because you cannot pass that data. I admit it varies, so the devil is in the details and you have to look at the details. But in general, this is a trend that will be quite challenging. Okay, and so that's something to think about. We talked at length about the digital economy agreements, and I just wanted to set out a few things. So first, these have been done by Singapore. And so Singapore, I think, signed the first one in 2020 with Chile and New Zealand. As Luca hinted, the really unique thing is this particular agreement is considering the entry of China into that agreement. So converting that 3-party agreement into a 4-party agreement. And maybe that's a new way of growing a multilateral. Instead of trying to get everybody to agree, you start off with a group of willing parties, and then you see who else signs on to it. I do have to point out that a lot of these digital economy agreements support paperless trading. So the countries in this room already also sign on to paperless trading by the CPTA. And that gives you one area in which you share in common with this group of countries already. And so maybe a digital economy agreement could be something on your own radar. There is an obligation to accept electronic documents with certain exceptions, a general obligation. There's an obligation to set up single windows to facilitate the exchange of data relating to trade administration documents, including phytosanitary certificates, import-export data, other agreed documents, very similar to the kind of obligations that you will be setting up in your compliance with the CPTA. As mentioned, there's also provisions on the electronic payments and free data flow. I do have to point out that all these obligations are quite loosely phrased. And so it's up to the parties to then set about specific areas in which they want to implement. So it doesn't mean that from the get-go, from the first day of entry, you need to fulfill all these obligations. They are subject to individual projects in order to achieve compliance in these areas, but at least you have some common starting ground with them. Further, agreements have also been now entered into with Australia, which went into force. The United Kingdom has just gone into force. And the most recent one has been signed with Korea. Yeah, I see our friends from Korea not in the room, but I do want to mention that the Korean agreement is quite significant because that's the first digital economy agreement between two Asian countries. And they specifically focus on digital payments, paperless trading, artificial intelligence, digital healthcare, and renewable energy building technology. And the other thing that's particularly impressive about this agreement is that even though it's signed, I think in the last 3 months, they have already started work on 3 areas. Okay, so you see very tangible projects being implemented pretty quickly. Again, these agreements are all available in text, except for the Korean one, as Professor Su pointed out. I think they have yet to put that up, but I think they could form the basis of some interesting ideas on your part, and some ideas also on what's happening next in the world of digital trade. With this, I thank you.
Thank you, Brian. That was very insightful. Now I move to the next and final speaker of the part 2, Mr. Sven Kalebo, Director of Tradeworthy.
Right. Good morning, everyone, and thank you, Sue, ESCAP and UNCITRAL for the invitation extended to Tradeworthy to share a bit of our experience, mostly in the Pacific and a little bit in ASEAN. Just one word about the company. So Tradeworthy is actually a solution provider. We are working mostly for the Austrian government in helping countries in Asia and the Pacific, but also organizations like the ASEAN Secretariat and the Pacific Island Forum Secretariat in implementing some of these agreements on the commitments made by countries in furthering the use of electronic commerce. So I'd like to echo what was said before and congratulate Tuvalu, and I think Mr. Falema is still online, for the accession to the Electronic Communication Convention and the Cross-Border Paperless Trade Agreements. It's a major achievement for Tuvalu. We play a very little part in that, and we are now working on the e-commerce strategy for Tuvalu, which obviously will include a very important part on trade facilitation and trade logistics, and will take advantage of this accession to even further the ambitions that Tuvalu has in that. So some of the previous speakers mentioned these global currents that are shaping digital policy landscape, the growth of digital trade standard initiative, the digital-only trade agreements like the DEA and the DIPA, the digital government policy standards, even in Tuvalu, in the Pacific, as we heard, the fact that countries are building future-proof and sustainable digital infrastructures, but also, and very importantly for the work that we are doing at least, is the democratizations of AI and of other new tool systems and programs. And the reason why I mentioned that is that when we started to work on, for instance, the e-commerce agreements back in 2019, the countries we were assisting at the time, Cambodia, Laos, and Myanmar, were really focusing on a few issues, on a few e-commerce issues, online consumer protections, electronic authentication, electronic contract, electronic signatures. But in the past 3-4 years, when we've moved to help countries, for instance, participating in the WTO GSI on e-commerce, those are the topics that were brought to the table. A lot of very new topics for these countries, for Cambodia, Laos, and Myanmar. Here you see on the left-hand side the topics as they appear in the EEA, DPA, or the WTO GSI, and in the column where those topics appear or where they are negotiated. So this is just to show the complexity of the implementation of commitments made by countries in Asia and the Pacific. It's not just about negotiating agreements, but also about understanding what you negotiate and implement what you negotiate, bearing in mind that in most economies, government officials rotate. So they change every 2 or 3 years. Sometimes they stay in the same department. Sometimes they move to another ministry. So it's very difficult to keep an institutional memory on what all these topics are and how they were negotiated for the countries. So we've heard a lot about e-commerce agreements today, so I'm not going to go into details. We've heard about these 3 main, I would say, trend that go into a whirlpool. On the ASEAN level, we have the ASEAN e-commerce agreement that entered into force in 2021. We have the outset provision on e-commerce, 1 chapter out of the agreements. We have the NZ FTA between ASEAN, Australia, and New Zealand that contains a chapter on e-commerce. And forthcoming, we have the Digital Economy Framework Agreements that hopefully will be negotiated at ASEAN in the coming years. We have the DEAs, we have the DPAs, and we have the WTO GSI. So it's a lot of complexity for most of the economies, especially the least developed countries. So our role is to try to make ways that these agreements and these new dimensions are mainstream into national development plan, into national trade development plan. We did that, for instance, for the ASEAN e-commerce agreements. So this an agreement signed, ratified by all member states by now. And this agreement was translated into an implementation work plan. So what we basically did is try to take all the chapters included in this ASEAN e-commerce agreement and look at where each of the 10 member states were in terms of these 18 different topics on the screen, and what was missing for those countries to be compliant with the contents of the agreement. So just giving an example here, and I will put a QR code on my last slide. You can scan the QR code and get access to this information. For instance, here, another heat map. I just extracted a few countries, Thailand, Indonesia, Cambodia, Laos, and Myanmar. So the heat map here, the color does not represent the level of implementation or the quality of the implementation of these different tools, laws, and regulation. That would be very subjective. But it just shows the gap between what was agreed in the e-commerce agreement and the current status of these countries vis-a-vis these laws and regulation. So I'd just like to echo what Brian just said on the issues of cross-border flow of information, data localization of computing facilities, which we see as kind of worrying trend of a number of regulation being developed or imposed in the past few years. So not only we map out where the countries are, but we also try to make a work plans on how to bridge the gap. And obviously, in e-trade facilitation, we use the good work that's been doing by UNCITRAL, by ESCAP, and all their partners to make sure that the countries are aware that in some cases, as Luca was mentioning, they're already party to these agreements, or that they have tools at their disposal, like the readiness checklist, like the legal readiness checklist, that could help them move towards further implementation. We've also participated in building work plans on e-commerce for the RCEP agreement, and here I'm not a government official, so I guess I can say a bit more of our experience, but the e-commerce chapters of the RCEP should have been the most exciting elements of the agreements because of the importance and the development of this sector in Asia and the Pacific. But I would say it was a bit disappointing in not going further than, for instance, what the ASEAN e-commerce agreement has. So I think it was a bit of a missed opportunity. Hopefully, this chapter will be revised and take on board all the development that has happened since the beginning of the negotiation. And I think it was Kun, what I read this morning, that was explaining that when they started negotiating, some of the agreement had not been yet endorsed. So we have had some difficulties, for instance, to explain to member states like whether they should focus right on the ASEAN e-commerce agreement and implement what's in there, or look at the e-commerce provision in our set, which are often very shallow. So we tend to help countries to focus on the ASEAN e-commerce agreement instead. In terms of what's next, this has been covered, so I'm not going to go into details on that. I'd like to focus more on the Pacific Islands. And in the Pacific, we have an agreement called the PESA Plus Agreement, which is a trade agreement that includes a trade in services chapter. And inside the trade in services chapter, you have a few mention of e-commerce. So just to say that it's almost absent from the agreements in terms of agreement among the different economies in the region. Only in the last version of the Melanesia Spearhead Group trade agreements, so it's an agreement with a few member states, there was a mention of the e-commerce. So we are not at a stage where e-commerce can be negotiated. However, I think, Sue, you mentioned that in the Pacific Regional E-commerce Strategy and Roadmap that was prepared by the Pacific Island Forum Secretariat, there are several mentions of negotiations that should take place, or preparing negotiators in the Pacific to negotiate on e-commerce discipline. We have a number of recommendations at the regional level, like the one you see on the screen, that e-commerce related laws are made or amended based on the UNCITRAL model laws as best international standards, plus other best international practices. And we were very fortunate, and we are still very fortunate, to have UNCITRAL and Luca in particular being very active in the region. So thank you, Luca, for kind of prioritizing. I don't know how you prioritize or how many countries you prioritize, but we feel like you're prioritizing the Pacific. And we developed, together with a number of organizations like ESCAP, UNCITRAL, WTO, a very comprehensive online program on e-commerce discipline for policymakers. This program was delivered for 12 countries in the Pacific, the 6 WTO member states and 6 others. It took roughly 2 months, and the course is now available online. It's accessible to everyone. It's a public good, so everybody can access. We have more than 34 different topics being covered in there, with different angles from development partners, but also countries themselves, regional organization, international organization. And I will provide a QR code at the end if you want to have access to this. So this means that with this e-commerce strategy at the regional level, we have also a trade facilitation strategy at the Pacific level being developed. Cross-border paperless trade and e-commerce are really coming to the front, and countries realize the importance of these tools and these agreements. We are currently helping 4 of these economies to improve the legal and regulatory framework for e-commerce and cross-border paperless trade from on the screen. So I hope you know the flags of the countries. So on the first center left is the Cook Islands, where we conducted a regulatory gap analysis and benchmarking on e-transaction, data protection, consumer protection, and cybersecurity, as well as on payments. Below is Tonga, which has, I think, has already completed its technical readiness. And we are working on an option paper on e-commerce law with the focus on consumer protections. We also work, the flag on the right-hand side, with Vanuatu on the regulatory gap analysis of e-commerce related laws, with particular focus on update on e-transaction. And finally, Tuvalu, where we did a gap analysis and recommendation for a new package of e-commerce laws. So our role is to make a gap assessment, make recommendation, and sometimes help the countries move these laws to cabinet. And before that, we ensure conformity and compliance with the main text, especially through UNCITRAL. So the main takeaways of this work we've been doing in the past 3 years. So on the right-hand side, you have 3 QR codes that you can just scan and then download the corresponding documents. We have observed that in Asia and Pacific, COVID-19 has accelerated the interest and the understanding on e-commerce, and also the interest for relevant policies, laws, and regulations. increasing number of e-commerce and digital-only agreements at the bilateral, regional, and multilateral levels with binding and non-binding commitments. The complexity of e-commerce rules and disciplines for government officials. This is the main challenge we are facing in promoting this work. The fact that negotiation of these agreements is just only the beginning. Implementations and the uptake, the dialogue with the private sector are also very much critical, essential. And in the case of Pacific Island countries, they start to realize the importance of e-commerce rules and regulations by participating in this Pacific e-commerce strategy, by participating in different fora, by acceding to some of the conventions as to value, making progress towards more participation in multilateral discussions and in adopting legal instruments. So I leave the slide on the screen for like 1 minute if you want to scan the QR code. This is public information, and I guess the slides are also on the UNESCAP website. Yeah. Thank you.
Thank you very much, Sven. I think it's really encouraging to see these activities happening in the Pacific, regardless of the geographical limitations and the size of the economies. They are moving forward. And yes, COVID-19 has a silver lining in that regard. I am aware of the time, but I'll take any questions from the floor. Rama, yes.
Thank you. Thank you for the nice presentations, and it's quite actually exciting to see that a number of the countries actually are more into the digital trade agreement. And one thing that actually I want to point out is that unlike the other the e-commerce articles in the free trade agreement, one big difference that I see in this digital partnership agreement is that they have a specific trade document in the article, which is e-invoicing. So since you have missed out that part, I just want to elaborate that unlike the other like the complicated documents which has a lot of the difficulties in realizing in e-commerce, like EBL, e-invoicing is rather simple somehow, which is the most one of the most significant important trading document. So as a practitioner, I'd like to point out that this invoicing is something that can be some cornerstone to facilitate the cross-border e-commerce and paperless trade. Thank you.
Yes, thank you for the comment, Rama. And you're right. I did not see the significance of the invoicing provisions when I prepared this, but I think the point you made from yesterday and today are good points. The issue, I think, is also, as you pointed out, the countries haven't agreed how to mutually recognize e-invoicing across borders. I think within borders, some of the countries have said we will recognize PEPAL e-invoicing standards for our own internal government recognition of e-invoices. We encourage that, but whether they would recognize the standard of another country, I think that's where, as you pointed out, some of the trickiest parts would be. But yes, that would also help what we're trying to do here. Thank you.
Okay, thank you very much. Any others? Hassan, please make it short. We are running out of the time.
This is addressed to Brian. You mentioned about UK, Singapore DEA. Is there any element of MLETR built into it?
Yes, so there is a hint of mention in some of the the digital economy agreements of the ability to accept trade and financing documents based on blockchain technology. The tricky part about this is a lot of the countries haven't signed on to MLETR yet. So they will be very hesitant in agreeing to fix obligations on that currently. But we certainly do anticipate more provisions coming on once more countries SC to MLETR. I think currently the count is only 8. And of the countries that Singapore has signed DEAs with, none of the rest have signed on to the MLETR yet.
Yeah, that's what my concern, that I wanted to understand. Your professor also in the forenoon session said that the DEA Singapore UK has an MLETR built into it. And that's the reason that I wanted to know this, number one. And number two, second thing which I just wanted to add to your presentation, that under the consideration heading, you have mentioned some G7 and others. I think there is an element of G20 also considering this MLETR, maybe for your reference.
Oh, thank you very much for that. I wasn't aware that it's been discussed at a G20 level, but helpful to know. Thank you.
Okay, with that, we will conclude the session here. I just wanted to repeat my sincere thanks to UNCITRAL, especially Luca and Atita. They have been really leading the preparation and recruitment of the speakers and really making this session productive. So thank you very much. And we have distributed a copy of Cross-Border Paperless Trade Toolkit that I have mentioned, one for a country. So I hope it will be useful. And housekeeping, we will provide a light snack lunch outside as usual. And please be back in this room at 1 p.m. for standing committee. Thank you.